Good afternoon, everyone. Whew. It's a huge challenge to follow a presentation or a debate by Lillian and Philip. So please bear with me. My topic is, so the topic of the presentation is current developments in taxpayer rights, and I'm going to focus on an international aspects of this protection of taxpayer rights. I would like, taking the debate from where Philip stopped, to show a little bit on the evolution, what happened regarding the evolution of the protection of taxpayer rights during the last 20 years, and the fact that we are already here at the fourth international conference with the only subject, the protection, the taxpayer rights, already shows something that maybe this topic has moved from being just a wish or something marginal to a main topic in the international tax agenda. Then I will move to present some recent developments in select focus areas, and these two areas that I'm focusing on today is the right to a fair trial, as I think we are now experiencing or monitoring the creation of a new tax landscape for map and arbitration in international tax cases. And the second topic, a different one of course, the issue of enforcement of taxes, which is equally important for tax administrations, tax authorities struggling to collect revenue, and at the same time taxpayers being subject to some extensive powers from the tax authorities. And in particular, I would like to refer to the case that is known as tax hostages. I liked very much, actually I found it very appropriate what Shelley said earlier today, that we should distinguish between taxpayer rights as in the position of the taxpayer as a customer versus the position of the taxpayer as a citizen. And what we see, I think, now is a transition from one side of the spectrum towards the other. In 1990, the OECD report on taxpayer rights and obligations indeed referred to taxpayers' rights as a tool to help build the trust in the relationship between tax authority and taxpayers, with the aim of making compliance easier. This, I think, would fit with the definition or the definition of taxpayer rights, seeing the taxpayer from the point of view of the tax administration and the taxpayer as a customer. In 2001, I like that one, that's why I'm stealing Philip Baker here. He made an interesting choice of words, that some would say taxation and human rights is an oxymoron. Maybe that was the case still in 2001. But as Philip explained already earlier, this is not the role of taxpayer rights. This is putting the limit to what tax administrations, to what states can do to taxpayers. And next big stop in this evolution timeline, I would say, was the 2015 general report in the IFA Congress, where taxpayer protection, the practical protection of taxpayer rights, was the main subject. At the international level, Pasquale Pistone and Philip Baker again made this, gave us this general report with were identified minimum standards from all over the world and on rights that have a global application. And now we see, since last year, 2018, the IBFD has already set up this observatory for the protection of taxpayer rights, and now I think we are confident enough to say that there is a clear and undeniable relationship between human rights and taxation, with human rights directly influencing different facets of the tax relationship, both materially and formally. Moving to the next part. Now, for this presentation, as I said, I will focus on two issues, and these two topics were selected because, first of all, there are current developments in the sense that, one, for the dispute resolution, states are getting ready to implement new rules through the MLI arbitration and for a number of states, and mostly In the European Union, a new landscape is forming, and this is what I would like to point out a little later. And of course, what we see in the report that will be presented tomorrow, that you will see that these two topics have the largest number of cases reported. So it's not only about cases that have already been decided, but also about issues that are going to be brought before the European Court of Human Rights or the Court of Justice of the European Union or the Inter-American Court of Human Rights in relation to these issues. So I think there is a strong trend that we will be dealing with these issues in the future a lot. Right to a fair trial, therefore, and you can find more information on the respective section of the report, on the observatory report, and the enforcement of taxes. Again, you will find more information. So the first one, right to a fair trial and tax procedures. Of course, everyone, we all know that, who is subject to any kind of measure from the state that adversely affects his position has the right to participate in the proceedings leading to the adoption of such measure. This is identified as a minimum standard of taxpayers' protection in their interaction with the tax authorities. And what are the core elements of such a right? That the person must have, a taxpayer, must in particular, access to a dispute resolution body, that he's entitled to a fair and public hearing, he's entitled to a timely resolution of any disputes that arise, the right to adequate redress, equality of arms during the dispute, adversarial proceedings, right to a reasoned decision, and the right to have a final judgment that can also be executed, so enforced, implemented. Fair trial guarantees are especially particular in the areas of administrative cooperation between states. Three main areas: dispute resolution, where we find mutual agreement procedure and arbitration, exchange of information. I will not deal with this because I think there's another panel who is going to discuss these issues more in depth, and assistance in the collection of taxes. I will touch a little bit upon it, but not from the international perspective, only from the domestic one. For this part, I'm going to discuss dispute resolution. And the two issues that appear to raise concerns are, first one, particular one, the case of baseball arbitration and how it works, and then a more general one, the impact of recent case law from the Court of Justice of the European Union, and particularly the Achmea case. I will explain a little later what this is about. Baseball arbitration, one of the options, and I would say the default, not I would say, it is the default option in the MLI. Why would it raise concerns regarding its compatibility with fair trial guarantees? I identified three issues. First of all, it is in the MLI explanatory statement that when a decision is adopted in the course of baseball arbitration, this is adopted by a simple majority of the panel members, and it does not include any rationale or explanation. This is already a point to keep in mind. Secondly, you have no publication of this decision. You have rules for confidentiality that do not allow the publication of the position presented before the dispute resolution body, and there is no, therefore, other obligation to make the decision, the reasons, any reasons, public, but first of all, you say we don't have any reasoning behind it. Not written one, not an obligation. Third one, the limited powers of the panel members. Now, what happens if neither of the proposed solutions is compatible with the relevant DTC rules? So they are both contrary to the law. The panel members have only the power, the authority to choose one of the two proposals that have been presented to them. They are bound to. They cannot deviate, or they cannot choose a third option. These three issues are one aspect. There's another aspect also that has to be taken into account, and these are good tax governance concerns. Having in mind the design of baseball arbitration with these three particular issues that I described earlier. What happens with transparency in the way that competent authorities exercise their authority? Of course, I refer to the Caesar's wife standard in the sense that competent authorities, we may know that they will act in a good, proper manner, but they also have to show that. It is not enough that they are not guilty. They must be beyond suspicion. Second one, principle of legality regarding the imposition of taxes. And I'm linking this to the fact of the two proposed solutions that are both contrary against, not in line, not compatible with the relevant DTC. Can it be acceptable, an acceptable solution that the outcome of baseball arbitration is a decision that is not lawful? I have had some doubts. And the third one, I often hear as an argument that there is no obligation from the part of the taxpayer to agree on the proposed solution by the competent authorities in the context of a map and arbitration. But I really cannot accept this argument. Is this the waste of resources that we are thinking that it is a good tax administration? Are we going to use a procedure only for the taxpayer in the end not to accept for whatever reason? It can happen, of course, but can we start with these premises that we can allow some faults because in the end the taxpayer will not be obliged to accept it, so no harm. These are my concerns regarding baseball arbitration. Moving a little bit to the general idea, the general perspective of MAP and arbitration, what happened in 2018 that I think affects the design of MAP and arbitration is the decision of the European Court of Justice in the Acmea case. This case is not a tax case. It's a case that concerns the compatibility of arbitration clauses in the bilateral investment treaties. And what the court said is that these arbitration clauses are incompatible with EU law. The reason why these are incompatible with EU law is that they remove a group, a part, a number, a core body of disputes that involve the interpretation and application of EU law from the mechanism of judicial review provided for by the EU legal framework. And therefore, the Court of Justice cannot exercise its authority. That was the problem with the BIT arbitration clauses. Now we know that the jurisdiction of the Court of Justice is related to the subject matter of the treaties. And we also know from previous case law of the Court of Justice of the European Union that disputes concerning the application or interpretation of double tax treaties these disputes have a strong link with the subject matter of the treaties. Now, putting all this together, can we say that DTC disputes, can they be removed from the supervision, the effective supervision of the European Court of Justice? And how we do that? By taking this body of disputes to the MAP and arbitration. And the question then is this: is MAP and arbitration under DTCs incompatible with EU law after these case law of the Court of Justice? This is where we are possibly heading. From the impossible to the inevitable. What was impossible some years ago to even discuss the participation of the taxpayer in MAP and arbitration that is traditionally viewed as a procedure between tax authorities. What is the inevitable? That we may have to face this reality now, at least for those cases that involve disputes and dispute resolution mechanism with EU states. What leads us to this conclusion? The fact that we are dealing with disputes arising or involving application and interpretation of double tax treaties, the principles of good tax governance, explained a little earlier, the fair trial guarantees that it is a positive obligation of the states, and the fact that the Court of Justice has already expressed its views on the scope of its jurisdiction. maybe we are moving towards making map and arbitration under tax treaties a more judicial procedure in which the taxpayer is also a party. Second part now, moving to another area, enforcement of taxes. Tax enforcement. This entails, we all know, greater powers for tax administrations, and of course, the greater the powers of the tax authorities, the more risks there are for practices to be potentially harmful for taxpayers, and therefore the stronger the safeguards for the latter should be. Measures and guarantees in relation to enforcement that have to be taken into account is, first of all, protection of minimum vitalis, a reasonable possibility of deferral of payment of taxes or payment in installments while safeguarding, of course, the interest of the revenue by accruing interest and proper guarantees. There are a lot of issues in practice with seizures of bank accounts and other assets, especially when these procedures are automatic or expedite. And a last one, travel bans and revocation or denial of passport. And this is what we refer to as the case of tax hostages. Indeed, the rights to leave a country, including one's own, it is included in most major human rights instruments. It is intended to ensure that people can move freely, including out of the country they are in, without unjustified obstacles. Can this freedom be restricted? Yes, it can, for reasons that are, of course, justified, necessary, and proportionate. I'm going to use an example, an earlier case of the European Court of Human Rights, to illustrate what can happen with the application of such measures. It's quite a case from some years ago, 2006, and during the years in question, Bulgaria, so the state involved, was not a member of the European Union. What happened was a certain Mrs. Riener had dual nationality, Austrian and Bulgarian. She was the director of an Austrian company that was registered as a trader in Bulgaria. And in 1992, this company owed a huge amount to the Bulgarian tax authorities. That was around $1 million, unpaid taxes and interest. In 1995, the Passport Department of the police issued an order imposing a ban on the applicant from leaving the country and ordered that her travel documents be seized. Indeed, this has happened, as when Mrs. Riener tried on the 4th of April 1995 to cross the Bulgarian border to Greece, the Bulgarian authorities stopped her and confiscated her Bulgarian passport. Her Austrian passport, sorry, she did not have a Bulgarian passport. The travel ban was maintained in force via internal notes from the fiscal authorities, which periodically informed the passport police that the debt had not been paid, and it was finally lifted in 2004. During the same time, Mrs. Riener also made several attempts to renounce her Bulgarian citizenship, and all these attempts were rejected. Her request was finally granted in December 2004. It was strange, but she didn't leave the country even after the bans were lifted. And that gave rise to a question by the court, which addressed this question to Mrs. Riener, and she replied that she had stayed because she needed to organize the liquidation of her husband's company in Bulgaria, and that she would leave as soon as the liquidation procedure was completed. So Mrs. Riener was a tax hostage for 10 years because she could not freely leave the country. The court assessed this situation under the three standards that the court uses. First of all, whether this measure was a lawful one, and the answer is of course yes, because it was provided for in the law. The second one was whether it pursued a legitimate aim, and here the court also said yes, because the legitimate aim in this respect was to secure the payment of considerable amounts of taxes. But what was the problem was the proportionality of this measure. So maintaining the travel ban automatically over a lengthy period of time may become, in the court's word, a disproportionate measure violating the individual rights. And nice quote from the court, a restriction cannot amount to a de facto punishment for inability to pay. Of course, you may say this happened in the 90s, somewhere in the Balkans. These things may not happening today, or are they? Or may they happen? And it was interesting because I saw that Nina already in January and maybe earlier or again made some interesting comments on the IRS revocation or denial of passport in case of certain unpaid taxes. And the point here is that if a person is not properly informed or timely informed of what might happen, or not being given alternatives on how to deal with the issue, there may be a constitutional issue. Of course, and thankfully, we have case law and practice that we can look at and see suggestions and proposals on how to design rules that respect proportionality in this respect. It seems that there may be only one solution. I hope there is not only one solution. Thank you very much for your attention.